Welcome everybody. This is the CBAFF Risk Management, Demurrage, Detention and Liens webinar, which we will be starting in about 4 minutes. Welcome everybody to the CBAFF webinar, which was going to be starting in 1 minute. This is the Risk Management, Demurrage, Detention and Liens webinar. Good afternoon and welcome to the Customs Brokers and Freight Forwarders Federation's webinar on risk management, demurrage, detention and liens. My name is Rosemary Dawson, CEO of Customs Brokers and Freight Forwarders Federation. At this meeting, members are reminded that there must be no discussion of prices, surcharges, fees, costs, particular customers, revenues, market shares or any other commercially sensitive topics, and in particular I'd like to remind you that no market agreements have been or will be decided at meetings of CBAFF, whether they involve prices, amount or areas. And I would like to also make you aware that such behaviour outside of meetings is prohibited, otherwise you could cause immense damage to CBAFF and or your company. And should it be apparent that at a meeting there is an attempt to make or discuss an open or hidden agreement regarding price, amount or area, I'm obligated to intervene and if necessary break off the meeting. You're advised that today's webinar is being recorded and the recording will be made available following the conclusion of the webinar. It's with much pleasure today that I introduce Simon Cartwright. He's a partner at Hesketh Henry Disputes Team. He's a transport and trade law specialist with particular expertise in shipping, marine insurance, logistics, commodities trading, trade finance, and international debt recovery. He acts for ship owners, operators, exporters, importers, logistics companies, ships agents, brokers, port operators, P&I clubs, marine underwriters, and commodity traders. Before I ask Simon to speak, I remind you also that there will be a question and answer opportunity at the conclusion of this presentation. The questions will be held until the end of the presentation, and I will put those to him during the Q&A. We have received one question leading up to this webinar, and Simon assures me that he will be covering it, particularly about shipping lines threatening to hold and withdraw services as a lien. So over to you, Simon. Thank you.
Great, thanks Rosemary, and thank you to CBAFF for the opportunity to talk about what is, I know, a very vexing issue for you all at the moment. Just before I get into it, I just want to make sure, Rosemary, that everyone can see my share screen.
Oh, yes, we can see that, Simon. It's all good.
Thank you. Right. Today I'm going to talk about risk management, specifically relating to demurrage, detention, and liens. Before I get into it, I wanted to make a few observations which hopefully give some context to what I'll talk about in the presentation. The first is, having done this for almost exactly 20 years, what you see, and I'm sure what you have all seen over time, are market fluctuations. And although driven by something specific, in this case the COVID pandemic and its related issues, shipping is a market, and prices go up and down. What you always have to look at in any situation ultimately is the contract, and I'll talk a lot about that as I go through the presentation. The second observation is shipping is also an inherently uncertain industry, and ultimately, again, from a legal perspective, what the law and what contracts really come down to is an allocation of risk around that uncertainty. In a cargo context, it's an allocation of risk between the carrier and the cargo interests. And again, it's something I'll talk to more as we go through the presentation. The last is not an observation, but just an interesting comment. So I was pulling into the car park at work on Tuesday morning, and I had a phone call from an unknown number. And when I answered, it was an importer who I hadn't spoken to before. And he wanted to grill me about the topics we're talking about today. He wanted to know why he was being charged freight twice what he was quoted. He wanted to know why he was being charged detention. And a topic, I guess a word that came through regularly in that half-hour conversation was, it was really unfair. As luck would have it, I was meeting later in the morning with a representative of a carrier, so one of the large shipping lines. And in the context of that conversation, we talked about the same issues. And what was interesting was the perspective of the carrier, which was it was all very unfair that they were being asked to effectively fund delays which weren't their fault. What's the point of relaying that story to you? It comes back to that idea of risk allocation, who should bear the risk, and that ultimately sometimes life isn't fair, but actually someone has to pay at the end of the day. So what I'm going to run through with you over the next hour or so, I'm going to set the background in terms of contractual issues by looking at the carrier's terms and conditions. I'm going to dive into, I guess, the issue we really wanted to talk about today, which is demurrage and detention. I'll touch on liens, which obviously are intimately linked to detention in particular. We'll run through a few risk management strategies and finish up with some questions. Right, looking at the contract, and as I said, the contract always in law is critical. What I've done here is take from, in this particular case, Maersk's standard bill of lading terms and conditions, some of their key provisions. I've used these because they are standard across most of the main carriers. Give or take, you'll see these in all the standard terms and conditions. Give or take, you will see them replicated in house bills. I sometimes think it's important actually to go back and look at them and really think about how they frame contractual liability and responsibility. And you may get bored by the end of this webinar with me saying you've got to look at the contract. That's where it starts, and it's really understanding what you've signed up to. And I guess customer facing, it's also explaining, to the extent you're acting as an agent, what they have signed up to or what you've signed up to for them on their behalf. So some key provisions. In the definitions, typically in the liner's bill, there'll be a reference to the merchant, and it will say that the merchant includes the shipper, the holder of the bill, the consignee, and the receiver of the goods. Why is that important? It's important, as you'll see later on, that the carrier wants to be able to make a recovery from whoever it can. And it deliberately has a very wide definition of merchant so that it can go after the parties involved in carriage. Typically, there'll be a specific reference to the carrier's tariff, and it will say that the carrier's tariff is incorporated into the bill of lading terms. And again, typically there will be a specific reference to the fact that there will be free storage time and container demurrage and detention. One of the challenges always, I think, facing customers in particular is identifying what the terms and conditions are. Typically, as you'll know, you'll get a face page of a bill of lading that refers to terms and conditions that are on a website somewhere. Normally, they're pretty accessible. Sometimes the tariff isn't that accessible, but when it's specifically incorporated into the bill of lading, it's crucial to know what tariff applies and to have a copy of it. Linking back to the definition of merchant, what do we have next? The carrier says the merchant, whoever that is, they're jointly and severally liable. In other words, the carrier can go after the shipper and the consignee. The carrier wants to make a recovery. It doesn't matter to them who they make the recovery from. When I was at law school in my tort class, I had a fabulous American professor, and he said the only rule of tort is that you don't sue the person who's wrong, you sue the person who's got the money. And I'm being a bit flippant, but the whole point of these provisions is to allow the carrier to make a recovery from someone who can pay them. And there's a specific reference in that merchant responsibility provision to the fact that where containers are provided by the carrier, they have to be returned to the place designated, and they have to be returned in the time prescribed. And there's a liability for detention or losses if they're not. When you strip shipping back to the bare bones in a carrier cargo context, there are some key responsibilities. The carrier's responsibility is to carry the goods from A to B in good condition, and the cargo interest's responsibility is to pay freight. And freight's always been a fundamental principle of contracts for carriage. And this simply recognises that freight is payable when earned. Interestingly, it also talks here, and this is why I've highlighted this, it talks about all sums payable. So not just freight, all sums are payable. All sums that are payable are due on demand. And freight, in particular, has to be paid without set off. So you can't deduct from freight. The provisions will go on to talk about liens, and we'll go into that in some depth a bit later on, and it will say that there is a lien on goods and documents, typically the bill of lading if it stands as title. Again, for sums payable, and that distinction between freight and sums payable is important. Typically, there will be broad discretion and flexibility on the carrier's behalf as to methods and routes of carriage. So how they get the goods from load port to discharge port. Importantly, there will be a provision that says that anything that's done under that discretion is not a deviation. Why is that important? Well, I'll talk about this a little bit later on in terms of a carrier's liability for delay. But what they're really saying here is, look, if I exercise my contractual right to reroute the vessel or to transship a container or to repack goods, it's not considered effectively a breach of my obligation to take the cargo from one place to another as expeditiously as possible. Lastly, and this is really one that lawyers only probably focus on, typically in your international line of terms and conditions, the default law and jurisdiction clause is English law and English high courts. Why is that important? It's important because if you decided to sue the carrier under the bill of lading, you can't actually, in theory, sue in New Zealand. You'd have to go off to England. And either way, even if you did decide to sue in New Zealand, in theory, you'd be subject to English law. Does that make a real difference? For the purposes of New Zealand, probably not, but it's just something to keep in mind. Right, that sets the contractual background. I'm going to talk a little bit now about demurrage and detention. Just by way of background, when I started as a shipping lawyer, most of my initial work was in the bulk industry. There was some container work, but most of it was bulk. And when I learnt about demurrage and detention, it's in the context of a charterer who keeps a vessel for longer than he's supposed to. And in bulk shipping, demurrage is liquidated damages where a charterer takes longer than they should have to load or discharge the vessel. And detention is damages if they otherwise detain the vessel during the voyage. Those terms have been borrowed effectively by container shipping, but as you'll see, they're in quite a different, or they're applied differently, and that difference is really important when it comes to thinking about how and whether you can challenge detention or demurrage charges. So in the container context, when I talk about detention, I'm talking about a cost for the use of the containers before or after it's in a port or a terminal, and after the free time expires. When I talk about demurrage, it's the cost for the use in the port or the terminal, again, after the free time expires. Coming back to my earlier point, the liability, well, the accrual of demurrage and detention and the liability to pay it will always depend on the terms of the contract. It always comes back to the contract. That's where it starts, and in many cases, that's where it ends. So you've always got to look back to your contractual terms to see what is the regime that imposes the accrual and the liability to pay demurrage and detention. Here's where I suspect I may not surprise, but I may disappoint some of you. In principle, demurrage and detention in a container context are lawful. There's only really one case in New Zealand that even touches on the lawfulness of, in this case, particularly detention charges, which was a case called Cargo Coordinators and Cubic Transporters back in 2012. In that case, the containers had been returned very late by the end customer. They were 75 days late. detention charges had applied, and ultimately this was a fight between two intermediary parties as to who should pay. A statutory demand had been issued because Cubic hadn't paid, Cargo hadn't paid the detention. Cubic, I think, had already paid it to the carrier, so they were trying to make a recovery. And they issued a statutory demand saying this is a debt that is due. The discussion in that case really was around the law on statutory demands and when a debt is due, but there was some interesting discussion, and although I really recommend people read cases, this is actually quite interesting if you want to, something before you go to bed tonight. There was some interesting discussion around industry practice, some discussion around what was reasonable in terms of rates of charge. What the court did in this case is refer to an Australian decision called Ichiban Imports and China Shipping. And although it didn't specifically find on this point because it didn't have to, I think the implication is that New Zealand would have followed the Australian position on detention charges. And that position is that detention charges are a daily charge for the use of containers. They are not considered to be liquidated damages. So you remember I said in a bulk shipping context, demurrage is something slightly different. It's considered to be liquidated damages. In a container context in Australia, and I think this is the position in New Zealand, it's not considered liquidated damages. It's simply considered a daily charge. That's important because when people talk about container charges or detention charges or demurrage charges being unfair or being a penalty, and a penalty in particular, ultimately we have to look back at the law and determine what the law says about penalties. Taking a slight jump to one side, interestingly, in New Zealand, Australia, and the UK, the law on penalties has changed quite recently. Traditionally, the position in relation to penalties was firstly that it had to arise in the context of liquidated damages. The liquidated damages themselves had to arise from a breach of contract. So looking at our bulk shipping demurrage example, they are liquidated damages because the charterer has breached his obligation to return the ship to the owner within a specific period of time. And the liquidated damages, the law said they had to be a reasonable pre-estimate of what your loss is likely to be. So they have to be related to an actual likely loss that you might suffer. They can't be disproportionate. They can't be a penalty effectively. In the last couple of years in England, the law has changed slightly, and New Zealand has followed that position. A case recently in New Zealand, 127 Hobson Street and Honeybees, was all about the New Zealand position on penalty clauses. That case is in a very different context. So that was a commercial situation where there was a commercial lease between the two parties. It provided that if the lessor did not, in this case, put in a second lift to the property, there was a provision that they had to pay liquidated damages. They challenged that obligation on the basis that effectively it was a penalty, and the discussion was all around whether it had to be a reasonable pre-estimate of loss or something else. And the New Zealand courts followed the recent English authority, which was actually the test isn't pre-estimate of loss, it's all about disproportionality in a much broader sense. And part of that is does the party entitled to the liquidated damages have a legitimate interest to them? The Australian position slightly, it also required that there's a breach of contract. So in other words, to get your liquidated damages, there still has to be some kind of breach. The Australian position is slightly different in that they don't require a breach. And in the shipping context, there's some interesting discussion in Australia around whether that means it might be easier to challenge detention charges. So just to recap, in New Zealand, we think the situation is that demurrage and detention charges in principle are lawful and recoverable, subject always to normal contractual terms. So again, you've got to start with the contract and see what it says. Any position in law is not hard and fast. It always turns on the facts. And a good example of this is a recent-ish English court decision called MSC and Cottonex. In that case, MSC had shipped containers, I think it was containerized cotton, they'd shipped containers to Bangladesh. The receiver refused to take delivery of the containers because the market had collapsed and didn't want the goods anymore. The containers were held by the Bangladeshi authorities in the port. And the reason they'd done that is there was an ongoing issue around ownership of the goods. MSC, they own the containers, they're out of pocket. The demurrage that had accrued was substantial. I think it was around $1 million. Coming back to my first slide, where I looked at the carrier's terms and conditions, and one of the first points I made was, well, you've got to look at who is the merchant and what is the merchant's responsibility, and it's all about the carrier wanting to make a recovery from someone. So, in this particular case, MSC probably thought it would be difficult to make a recovery from the receiver in Bangladesh. Possibly there were financial issues with the receiver. But happy days, they, under their terms and conditions, they've got the option to go after the shipper. So the terms and conditions are broad and it covers the shipper and the receiver. So they claim and sue Cottonex, who are the shipper, for demurrage under their terms and conditions, saying you're a merchant and you're jointly and severally liable for the cost of the demurrage. The case ultimately turned on one point, which was that after a period of time, it became clear that the shipper could not recover the goods. And what the court found in that particular case, effectively there was a guillotine. So they said, look, you as the carrier, you can't let the goods sit there indefinitely, accruing demurrage, knowing that a liability is building up in circumstances where actually the underlying contract can't be performed. So what they found in this particular case is that, yes, you're entitled to demurrage, but only up to the point where the contract could have been performed, and actually there was a point when it couldn't. And in this particular case, it was when MSC actually spoke to the shipper and said, hey, we don't think this can continue, would you like to buy the containers from us? And the court said, hey, that's the point where you, MSC, must clearly have recognised that the underlying contract of carriage couldn't be performed and it was frustrated. So MSC was entitled to demurrage, but only up to a certain point. I think that case would be followed in New Zealand. What do we take from the case? I guess two things. Firstly, the facts really dictate the application of law. In this case, we had some quite extreme facts. Secondly, and this is the unfortunate reality of life, I think, it was worth enough money to fight about. The demurrage was $1 million. You had two reasonably substantial organisations, probably backed by insurers potentially, and they decided it was worthwhile having a fight about. I suspect for many of you, when you're looking at issues of $1,000, $2,000, $3,000, even $10,000, unfortunately, that the cost benefit of taking legal action is not going to be there. And that's a sort of hard reality sometimes of life. And often the conversations we have with clients around these types of issues are exactly that. Yes, there may be something to argue about. Ultimately, you need to make a decision how much you want to spend in terms of cost and time pursuing it. which neatly brings me on to my next point. And one of the questions that came up in preparing for this talk: can you challenge detention and demurrage charges? Absolutely. If you think they are unreasonable, if you think they are unlawful for a particular reason, and examples might be that you hadn't been informed of the tariff, that the tariff changed after the contract was fixed, that a particular delay was caused by the carrier, yes, absolutely you can challenge them. There's nothing stopping you, and in fact, in some ways, I would say I would actually encourage those costs to be challenged. Coming back to my conversation with the representative of the carrier on Tuesday, one of the many things that was interesting in that conversation was that the person said to me, well, of course, we always listen to people who are questioning detention charges and demurrage charges. We're in the industry. Industry is critical to what we do. We may not agree with them, but absolutely we will always listen to them. So the short answer there is, if you think you have a reasonable concern, and I wouldn't even say it needs to be a lawful concern, but a reasonable concern around detention or demurrage charges that have accrued, absolutely you should talk to the carrier about it. I know in that context I've seen lots of discussion around a situation where a vessel has arrived late and it's rolled into a weekend or it's rolled into a holiday. Again, in principle, well, we need to look at the contract and what it says. If it doesn't exclude weekends and holidays, then time will run. But it does seem to me that in those circumstances, particularly if a delivery location or a delivery venue is not open, it does seem to me in those circumstances there's a reasonable discussion to be had with carriers and a potential challenge around cause of delay as to whether delay time should run, whether that's detention or something else. So again, short point is, can you challenge? Yes. Should you challenge? If you think it's unreasonable, either commercially and of course lawfully, then absolutely. Right, that brings us on to liens. I've copied here again the full lien provision from the Maersk terms and conditions, which will be the same effectively in most of the others, if not all of the other international liner companies. What is a lien? A lien is a right to retain possession of goods until payment is made. In law, liens arise in three circumstances. Over time, the common law, so this is the law that's been shaped by judges in Commonwealth countries, so England in particular, but also New Zealand, Australia, Canada. It's liens that the common law has recognised should exist. And a good example of this is probably a repairer's lien. So the law says if you're a repairer, and that could be a ship repairer or something else, if you're a repairer and you've repaired goods, you have a common law lien to hold those goods until you've received payment for your work. In law, again, there's traditionally been recognition of a ship owner's right to lien in certain circumstances. In New Zealand, that right of lien has actually now been recognised in statute, and that's the second head of liens that are recognised, statutory liens. So in the old Carriage of Goods Act, what is now the Contract and Commercial Law Act, there is a provision that recognises a carrier's right to exercise a lien for payment of sums due. The last area in which liens arise is contractual, and this is really what we're dealing with here. So parties can negotiate and agree between them that someone will have a right to lien over goods if they're not paid. This brings us on to lien in a container context. So looking at our particular provision here, I've underlined some key points. The first is that the carrier has a lien on goods and documents, and again, typically that's the bill of lading is the document of title, for all sums payable to the carrier under this particular contract, the contract being the contract of carriage evidenced by the bill of lading or the seaway bill. So the first point is the carrier is saying, I've carried your goods under this particular seaway bill or bill of lading. For this particular contract, I'm entitled to be paid. And if I'm not paid, I can hold on to the goods. What am I entitled to be paid for? In this particular case, it's all sums payable to the carrier. That's important. And again, it is always worthwhile checking the terms and conditions, because a lien only entitles the person to hold goods for sums that have firstly accrued, and only the sums that they are contractually entitled to. In this particular case, for example, if that had said for freight payable under this contract, the carrier would not have a right to lien for detention or demurrage. This is a contractual lien. You have to look at the words of the particular provision and determine what rights they have. Unsurprisingly, in this case, the carriers have said, we want all sums payable. So that will include freight, of course, but also detention and demurrage. That particular provision is what we call a particular lien. In other words, it's particular to the goods that are, in this case, carried under this particular contract. What this clause does is go on to deal with what we call a general lien. And this was one of the questions that came up during the discussion leading up to this presentation. A general lien extends the right to lien out to all sums payable, whether they arose under the particular contract or another contract. And the question was, can a carrier exercise a right of lien for sums that have arisen under a different contract? Well, the short answer is yes, if they have the contractual right to do so. If you are dealing with an international liner company, Maersk, CMA, CGM, MSC, I would say almost inevitably they will have a provision that says something similar to this, and they will have a right to lien goods owned by the shipper, consignee, or merchant as defined. Again, it always turns on the contract, and it always turns on the particular facts in your case. It's important that a notice of lien is given. So you can't, for example, simply sit there awaiting payment and if a dispute subsequently arises, say, I'm not releasing these because I've been exercising a lien. So if you are going to exercise a lien, you should give notice of a lien. In New Zealand, the other point always to be aware of is that a lien is a security interest under the PPSA. And in certain circumstances, it may mean that there is a priority if goods subsequently form part of a liquidation or a bankruptcy. Sometimes there'll be reference in forwarders' terms in New Zealand to the right to register security interests, and that's why it's there. It links into the lien provision. So that's a discussion about detention, demurrage, and liens. What can you do about it? Mostly practical things. Again, and I know I've said this several times, starting point always in terms of liability and responsibility is the contract, and that's where you've always got to start. Okay, but as forwarders, what can you do? A really good start is to ensure that both the terms and conditions that are forwarded, if you'll excuse the pun, that are forwarded to you by the liner, but also your own terms and conditions are clear, are transparent in the sense that they are easily accessible. Ideally, you would provide those to the customer. One of the risk management parts of my job is to draft terms and conditions for all sorts of participants in the marine industry. The challenge typically is not so much the terms and conditions themselves, it's making sure that they're actually brought to the attention of the customer. These are your contract. If you haven't provided them in advance of performance of the contract, they may not be valid. It's not enough to send them with your invoice at the end. You've got to tell people what they are signing up to. That's really critical. Sometimes it's hard, I understand that, but from a legal context, it's really, really important. When you come to talk to someone like me, we'll talk around the issues, and the next thing I'll say to you after that initial conversation is, I want to see everything that you've got. I want all your emails, I want your documents. Keeping really good written records, both in terms of documentation and communications and notifications, is really important again. That's the evidence. That determines the facts. From a legal perspective, but also from a practical perspective, if you are open and transparent and have clear and consistent communications, it will make your life much easier. In a forwarders context, again, it's really important to understand the capacity in which you're acting. And I don't say this lightly or flippantly. It ultimately determines your position, of course, facing your customer. Are you acting only as an agent, in which case your terms and conditions will apply one way? Are you a party to the Seaway bill or the bill of lading contract with the carrier because you've been named as a consignee in those circumstances where you've issued your own house bill, for example? Again, that really drives your own position, both facing the carrier and your customer. If you're acting as a principal under the head contract, then obviously you need to make sure that your terms and conditions and your position facing your customer is back to back, and you've got the ability to make a recovery. When you're making quotes, I guess coming back or touching on my first point, it's really important again that they are clear, that they are transparent, that you're identifying issues like free time, detention and demurrage as much as possible, that you're making it clear to customers their responsibility to pay, that you're making it clear to customers when and where containers need to be returned to if there are issues around peak periods. Obviously at the moment it's making it clear to customers that there are delays, and explaining to customers to the extent that you can, and I appreciate that managing expectations at the moment is really challenging. It's just explaining to them that actually there may be a responsibility to pay for costs that you can't exactly determine at the moment. Coming back to the point I made right at the start about risk allocation and this content, this issue, I suppose, of fairness. One of the benefits I've had in my career is as Rosemary's perhaps described, as actually acting for pretty much everyone. Fairness is relative. If you're a carrier who actually have had some pretty tough times, if you're a carrier, you might say, well, why should I bear the cost of a container sitting in a yard when it's actually not my fault? Port congestion in Auckland is not something that I've created. You've decided to ship goods from one place to Auckland. Why is that my responsibility? Equally, as a cargo interest, there may be things that the carrier does where you say, actually, why is it fair that the risk for that has fallen on me? Again, it all does depend on the circumstances, but you can help yourself enormously, it seems to me, as a forwarder, if you are clear, if you're transparent, and you've got really, really good operating practices. I guess in a practical context, again, it's, I'm sure, stuff you're already doing. Keeping a careful track of containers, when do free time periods expire? Are you telling your customers, again, often I feel that too much communication is not too much. It is all about keeping people informed and, again, to the extent possible, managing expectations. The law often is not that hard. You know, we've talked through, I hope, the background as to why the law says that in most circumstances detention charges are lawful. That's not always the hard bit. It's the managing customers, the managing relationships, and ultimately making sure that monies are paid when they're supposed to be. Again, I'm sure this is stuff you're already doing, but to the extent possible, having your clearance documentation ready for when containers arrive. So there is no delay possible on the part of the cargo interests. Again, does that help you? Potentially what it helps you with is a commercial discussion with a carrier around circumstances where the delay really does seem particularly unfair. Have consistent communications with the carrier. I saw a comment in preparing for this talk around the fact that in New Zealand in particular, what you're often dealing with are small offices who have limited discretion and ultimately perhaps limited decision-making ability. That may be so. But again, you know, having worked with carriers and different parties, I would say 99 times out of 100, there's actually goodwill there. They may not be able to do anything, but there's no harm in having a conversation with people. And the more of you that do that, and the more that there is clarity around those communications and cargo interest concerns, I think that can only be a positive thing. Lastly, just one thing to keep in mind. There may be a concern, there may be a challenge to detention or demurrage. It doesn't remove the immediate obligation to pay. There's generally a duty to mitigate loss. It may be that there is a requirement to pay, particularly where a lien has been exercised. I completely understand that may not be particularly palatable, but sometimes that is the best option to mitigate. You can pay under protest, so insisting that there is no liability. I completely, again, appreciate that may leave you in a situation where you are having to try and recover monies paid. As part of a negotiation with a carrier, and we've got this in a particular circumstance, perhaps you can offer to pay money into an escrow if there's a legitimate and reasonable dispute around the amount that is owed. Ultimately, what's a carrier looking for? They just want to know that they're going to get paid, and they want to know that they're going to get paid what they are entitled to. So offering security in the form of paying monies into an escrow might be an option that could be considered. Right, I have skated very quickly through some interesting points. I'm very happy now, Rosemary, to throw it open to questions.
Excellent, thank you so much, Simon. We've got 6 questions at the moment. The first one from Annette. In regards to routes of carriage, what happens if a letter of credit has a specific route and the shipping line changes that route?
there's no easy answer, I'm afraid. Your practical problem, of course, is that the letter of credit, well, if you're saying that the port of discharge has changed, then that's going to necessitate a new bill of lading or a new CBAFF bill. And that's really where your issue under the letter of credit arises, because suddenly your documents, and particularly your bill of lading, is going to be discrepant. We've seen this recently in a slightly different context in relation to log exports out of Australia to China, where because of the trade issues between Australia and China, it hasn't been possible to discharge in Australia and ships have been redirected. And there are, as you've touched on, there are a whole array of legal, logistical, practical issues that arise. Recovering original bills, replacing them with new bills, negotiating amendments to the letter of credit. With particular goods, do they need new phytosanitary certificates? Do they have to be fumigated? So it's a really long way of answering your question. I'm not sure I've entirely answered your question, other than to say it would be unusual for a carrier to unilaterally decide to go somewhere else. Typically that will happen in a circumstance where for a particular reason it's not possible to discharge.
Thank you, Simon. Next one from Bruce. Returned to place designated. If designated de-hire depot is full and we are advised to take to another depot, which causes FCL to go into detention while bookings are made accepted, then can we refute? And shipping lines seem to be reluctant to credit detention. If we don't pay the detention, they put us on stop credit.
Yep. I think that's a circumstance where absolutely you can challenge. That is an action by the carrier, a specific action by the carrier that has caused a delay. So the first point is, can you challenge? Yes, I would say you absolutely should. You've then hit, or you've identified, I think, what is a real practical issue, which is they still want their money in advance. And the third practical issue really does come down to this: how much is it worth to you to challenge? Often they will sit and exercise commercial pressure on you to pay. If you think it's wrong and unlawful, yes, you can still challenge it. But I completely appreciate, again, it doesn't put you in a particularly strong position, I guess, leverage-wise, facing the carrier. Coming back to the point I made at the end of my last slide, that sometimes that obligation to mitigate does override everything else.
Next question from Renee. You said, regarding the lien, you said that shipping lines need to notify that they are exercising a lien. If the shipping line don't advise and you end up with a detention and demurrage, what can you do to mitigate these additional costs?
I guess when I say giving notice, you have to know that there is money due. That's the first point. So have they actually sent you an invoice? And as stupid as it sounds, it's really important to check, because sometimes things get lost. So the starting point is, have you been notified that money is due? The next step is for you not to pay. And that's when really it's up to the carrier to say, or if you challenge payment, for the carrier to say that I won't release your goods until you do. That's the critical notice point. Again, it then comes down to why aren't you paying? And ultimately, if you were to follow that course through, and we ended up in court, if it was lawful for you not to pay, then you'd be entitled to recover monies that you did. You'd be entitled to cover your own costs and losses that resulted from the carrier's actions. If you were required to pay, then not only do you have to pay, you're going to have to pay interest on top of that. And again, as unfortunate as it is, sometimes your only practical option to stop time running and to make sure you get your goods is to pay, whether that's under protest or through some form of security.
Now from Rachel, regarding written records, if the shipping line is charging the consignee on the master bill for detention, but that consignee, e.g. forwarder, has contracted a third party to arrange cartage de-hire Sometimes there is no record of the attempts to de-hire. Slots are missed due to knock-on effect of unrelated containers being delayed, and the cartage companies simply cannot keep records of how one delay can affect the other.
Yeah. I guess the short answer to that is what you've described is not a carrier's issue. So what's the obligation of the carrier? It's to take the goods from one, pick them up at load port and discharge them at discharge port. And coming back to my comment about risk allocation, it just seems to me in that circumstance that what you've described from a carrier's perspective is not a risk that they would normally be responsible for.
I think we have a related question from Ryan. Can we class the inability to return containers to a named place a breach in contract? Example, delays due to bookings not being available, then incurring detention charges.
There would have to be, again, a really clear action or omission by the carrier that has specifically caused the delay. And I guess often what I'm described, and I think this is the previous question, is not actually necessarily something that the carrier has caused, but I guess what I would call a landside issue. And coming back to that allocation of risk and a court's instinct to where risk falls, I would say that it tends to fall with the cargo interest, not the carrier. So again, can you identify a specific action or an omission by the carrier that caused delay? If you can, then I would say it's worth it.
Another related question, how can the shipping line reasonably justify recovering costs when the container yards are over capacity and they refuse to take back the empty containers? We're doing our best to return them, no one's accepting them, and we're getting charged to hold the containers for the shipping lines as they physically cannot hold them.
And look, I think that's perhaps a good example of something where you say the risk falls squarely on the carrier. I don't disagree with that comment. Are you performing your contractual obligations by returning the container? Yes. What is the reason that you cannot return it? Well, it's because the carrier can't take it back. It seems to me, again, instinctively, that is a risk, or the allocation of that risk would fall on the carrier.
And another related one, what if the last free day is on a weekend or public holiday and the depot is closed, but the shipping line still charges you for not returning before the last free day?
Tough, I'm afraid. That's, you know, again, unless you carve out weekends and holidays, time runs.
And another one, on sending empties to an alternative de-hired point, what is the position on recovery of additional cartage costs to alternative de-hire points? Again, liability to the carrier, question mark?
It's a really interesting question. Without wanting to dodge it, I think part of the answer is going to be how much money we're talking about. The carrier is going to always fall back on their terms and conditions and look at the provisions that allow them quite a lot of discretion around all aspects of carriage. And I suspect that would probably fall within, changing the delivery location would probably fall within that discretion. But it all does turn on the facts.
She goes, and it goes on, it's not a one-off cost, it's the accumulation over many shipments. Without wanting to do an advertorial, CBAFF has been doing, having conversations with the container depots, and the Container Co advised me that they have got capacity at their Te Rapa depot, and they'd be delighted, and I would presume that's with the permission of the shipping companies concerned, to receive containers to that depot, with the fullness of the Auckland ones being recognised. I've fed back to them that with the capacity of trucking companies to have availability to deal with the current problem, that trucking companies may not want an extra 3 or 4 hour journey with for the de-hire of a container. But it's over to you to negotiate that, I would suggest, with your trucking company. So we've got a question about liens. Am I reading this correctly? A lien can be exercised by a shipping company for other shipments for unrelated cargo, i.e. not relate current shipment, which let's say has a detention issue under dispute.
Correct. If the goods are in the same ownership. If detention accrues under one contract and it's not paid, and the carrier is at the same time carrying goods by the same party under another contract, under that provision that I shared with you earlier, it's a general lien, and they would be entitled to exercise a lien on those goods.
And another anonymous question: if hubbing and additional storage charges are applicable since we cannot deliver, can we push these charges back to the lines?
Instinctively, no, again, unless it's been caused by a specific action or omission of the carrier. So again, in really simple terms, in what circumstances can you recover monies? Either it's because the contract says you can, or because there's been a breach of contract by one party. And so if you fall into either of those positions, then yes, you can make a recovery. Unfortunately, typically what I hear is something that doesn't, it falls outside of that.
That's the end of the questions that we've received. Thank you very much, Simon. We've got 47 participants remaining. We've got one question just popped in. David asks if weather is a factor that closes a depot or port, is the line justified in applying detention when denied to ability to fulfill delivery? Is this an act of God, and how would this fit?
So I guess what you're looking at there is what we would call a force majeure event. So I guess a really good example is the earthquakes, Christchurch, Wellington. Force majeure is almost an entire separate topic that I would be very happy to talk to you about on a different occasion.
Excellent, thank you. We'll book you in.
In really simple terms, under New Zealand law, and it's the same under English law, for there to be an exception to liability, it has to be set out in the contract. And the exception has to apply to your specific circumstance. So typically, what do we see in shipping? We see force majeure clauses that will say something like, neither party responsible for delay or failure in shipment due to one of the following events, and there'll be either specifically listed events or a general catch-all. You've got to have that provision in your contract, and you've got to fall within that provision for it to apply. I guess, Rosemary, just one final point. I certainly don't want to come across as negative in terms of what options you may or may not have. It's really often just a matter of being practical. And when you look at the cases that come through the courts, and now is a really good example of a time where actually a case clarifying the carrier's responsibility is probably long overdue, but it is driven by facts and it's driven ultimately by money. Why did MSC Cottonex get to court? It got to court because it was worth $1 million. If one of you has some funky facts and some money that's worth chasing, then it's probably worthwhile chasing, and some clarity would be good. Again, as someone who's done this for a long time, I would always just say to clients, beware of the law of unintended circumstances. In a carrier cargo interests context, one of my former partners wrote an article several years ago, and the heading was carriers for cargo interests nil. So in other words, cargo interests in 4 cases, and I've shared several of them with you, in 4 cases had run cases thinking they were going to win, and they all lost. as vexing and as troublesome as the situation you're in, it's still got to be worth it.
Excellent point. Thank you, Simon. And there's been no further questions. I'm sure if you've got questions that pop up after the close of this webinar, drop them to me and I can pass them on to Simon. I'm sure he'd be happy to have a one-on-one conversation with you. So thank you once again for participating in our webinar. Thank you so much for the contribution and preparation and delivery of the presentation, Simon. Very informative, and I think by the numbers that have attended today demonstrates the absolute relevance to everybody that was on the line. And remind everybody that this recording will be made available to you following the webinar. Most likely it'll be tomorrow that this will be up and available on the CBAFF website. So we've just clicked over 60 minutes. It's been great having you on board, and I'd like to declare the webinar complete and closed. Thank you.